now. Welcome, everybody. My name is Amber Hefner, and I am the Executive Director of Illinois Digital Educators Alliance. We're very excited to have you all here with us this afternoon. So thank you for joining us and learning more about SOPPA. We are excited to have partnered with IETL to bring you this three-part series. And I'm going to turn it over to our special guest and presenter, Greg.
Thank you for that. So let me just, while people are joining, introduce myself a little bit. So my name is Greg Reichelt, and I am an instructional technology specialist in Main Township, District 207, which is in Park Ridge, suburb of Crystal Lake, or not Crystal Lake, suburb of Chicago, obviously. At Greg Reichelt 207 is my Twitter handle. greichelt@main207.org is my email address. So why should I be giving this presentation? Well, I do teach classes. I still am in the classroom, but I've had the opportunity to speak to all of the lawyers out there and a lot of the technology leaders in Illinois that are grappling with SOPPA and trying to deal with it. And so I kind of have a good perspective as to, what teachers are going through and what district leaders are going through, and just kind of what everyone is going through. I also took some initiative in speaking to some attorneys. So I do have some perspective as to the legal side of things in terms of SOPPA, but I am by no means a lawyer. But I do think that I know enough about the law to be able to speak to it this evening. So during this entire session, I really would like you to be asking questions, and we're going to be having some Q&A discussion over on Slido. I don't know if you guys are familiar with Slido, but it's how I manage a lot of questions in my classroom. If you scan that QR code, that'll take you to a Slido link where you'll be able to ask any questions that you have as we go along, or you can just go to slido.com and then type in that number 30034 to be able to jump in. In Slido, obviously, you'll be able to ask questions, but what's really nice about Slido too is you'll be able to thumbs up and upvote questions. So hopefully at the end of the presentation, I'll be able to address the questions that are most urgent to all of you. It's a really nice tool for this type of thing. So as we're going through the presentation, I have left, my presentation should take around 20 minutes or so, but I've left about 10 minutes to answer questions at the end. And any questions that I don't get to, I'll definitely try and answer those questions at the beginning of next session. So definitely looking forward to your questions. I think that probably answering questions is going to be one of the best things that I can do to educate you all on SOPPA and why SOPPA exists and how what you have to do as teachers. So yeah. And by the way, I'm going to just go ahead and keep that Slido, the QR code, and the join thing on top of all the slides. So just answer your questions away over there. And then once I get to the end of the presentation, I'll take a look at those and start addressing them. So in this session, I really want to focus on what is SOPPA, the different legislative aspects of it. Why did SOPPA even come to be? Why do we need to comply with that? What are districts having to do? Districts have to come to these different agreements. Maybe you've heard about that, maybe not. I want to talk a little bit about how those agreements are reached. And specifically, I want to focus on the impact on teachers. So I know in here, we have a lot of teachers. This presentation is specifically addressed and it's geared towards teachers. So if you're an administrator here, you might know some of this information already, but if you're a teacher, this should hopefully be for you. like Amber said, we'll be providing the slides and everything to all of you. And I'd be happy if you decided to use them in your district. So feel free to use these resources if you want in the future. So we're going to start. I just want to watch just this quick video on what is SOPPA. It's just a really quick 1-minute thing, but I think it does a good job of summarizing some stuff. Yeah, so SOPPA is a law, and it was just passed in Illinois. Actually, SOPPA has been around for a long time, but it was amended in 2019. And the amendment goes into effect on July 1st, 2021. So districts, educators, everyone has until July of 2021, this upcoming summer, to be able to get everything ready and comply with this new legislation. SOPPA impacts all Illinois school districts, ISBE, and specifically all edtech companies. So ultimately what SOPPA suggests is that, transparency must exist between what students are sharing, and student data needs to be protected. So there's some very specific legislative aspects of SOPPA that districts have to comply with. So all districts have to have a written agreement between the district and all edtech vendors. And I think that this is one of the biggest things that SOPPA is. It's not the only thing that SOPPA is, but this is what a lot of districts are working on complying with right now, because this isn't just edtech vendors need to be SOPPA compliant or whatever, and they can just be okay. Every district actually has to have an agreement with every edtech vendor that's used within that district. So if your district uses Edpuzzle, your district has to have an agreement with Edpuzzle, and that Edpuzzle will be SOPPA compliant, and that has to be signed off on your district's legal side and Edpuzzle's legal side. There also has to be some security practices put into place in your district in order to protect student data. So student data is floating all around districts. A lot of people are using Google for everything these days. So districts need to put some security measures in place in order to protect that student's data. And SOPPA, it's very explicit about this. At the request of a guardian, the district has to be able to remove or change student data. And that's why the written agreements between the districts and the edtech vendors is super important, so that if a guardian says, hey, you need to remove my student's data from Edpuzzle or whatever, whatever edtech vendor the student signed up for, that edtech vendor has to comply to that. On the district's website, they have to have a list of all of the different resources, all of the different technology that's being used in the district, and a list of all of the data that's being collected by all of these different pieces of software. If there are any data breaches that affect more than 10% of students, the district has 30 days to notify all parents of that data breach. And so it's very important for districts now to be monitoring student data very closely to make sure that there are no data breaches. And if there are, they need to make sure that they notify everyone that those existed. So there's a lot of things that are being placed upon districts, a lot of mandates. But SOPPA also mandates that ed tech vendors are no longer allowed to. And by what I mean by an ed tech vendor is these are just technology companies that are supplying, gearing their whatever their platform is to students. So you're thinking like the Pear Decks, ed puzzles, things like that. Nearpod. Okay, these are applications that students use, and they're really friendly towards education, though that's an ed tech vendor. So ed tech vendors are not allowed to use data and use targeted ads. They can still use ads on their websites, but they're not allowed to target ads based upon student data. They're not allowed to profile any student. They're not allowed to sell or rent any of the data. It's very interesting to me in the technology realm. A lot of times different companies, they don't sell data or personal information, but they rent that information to other counterparts. So they're not allowed to do that either. They're not allowed to rent data, sell data, anything like that. Not only do the districts have to implement good security practices, but those ed tech vendors, those third-party websites that you're using with your students, they also need to implement some really good security practices to protect the student data. And then on request of a parent or guardian, they need to delete that data when requested. And then they also need to disclose any information if they do end up sharing that information with a third party, which a lot of vendors do. So for instance, a lot of our services that we use are actually being hosted on Amazon, and we're just not aware of that, right? Or like a lot of Edpuzzle, they store stuff on Google servers. So any of those relationships need to be disclosed, and they need to report out to everyone. So I just kind of went over like a lot of the legality stuff. And what does that just mean to you as a teacher? Well, ultimately, this law goes into effect on July 1st, 2021. And all educational ed tech vendors out there, anyone who is supplying your district with technology that you're using in the classroom, they must have a signed agreement. It's called a DPA with your district. There must be a process for parents to be able to exercise their right to delete data, and they need to be notified of data breaches. And when I talk about student data, I'm talking about things as simple as first and last name, email address, home address, grades, socioeconomic information, maybe even their photos. So the law is actually pretty clear. First and last name that's it. So if you're using a piece of software or a website or a service, and a student's name is being stored on that website, it needs to be SOPPA compliant. So why are we doing this? Well, it was really parent groups that fought for SOPPA, and they cared a lot about their student data. They were noticing teachers were having their kids sign up for websites, and then those websites maybe looked a little fishy to them, or they weren't really sure what was happening to the data once the teacher told them to sign up for these websites. So I think it's really important. It's legal and ethically our obligation to protect students and their data. So I think as teachers, we all really care a lot about our students. We want to protect our students. But in this new digital age, when we talk about protecting our students, we really need to protect their data. So security doesn't just mean physical security. Unlike at any other time in history, society is tracking us and monitoring every single thing that we do. So if this student data is breached, it can lead to someone finding out addresses of your students, contact information, potentially viewing personal information on that student that's meant to be private learning, physical disabilities, medication that they might be taking, or even potentially stealing a student's identity. I know students, people under the age of 18 are actually targeted for identity theft because a lot of, like, if my identity was stolen, I would know about it relatively quickly because I monitor my credit report and I'm aware of like what's going on with everything. I have my credit score locked, but students don't, and they're not monitoring their credit reports. So stealing minors' identities is a huge issue right now. And we as educators need to do our job to be able to protect them. And one way that we can do that is making sure that all software, all services that we're using are SOPPA compliant. So I did mention these DPAs, or these agreements that schools have to enter into. Every district can create their own agreement with every software piece out there. But Illinois has actually really come together and has started using this National Data Privacy Agreement. It's called the IETL NDPA. And basically what this allows is if a district signs an agreement with an EdTech vendor, and that EdTech vendor agrees to everything, another district in Illinois can piggyback on that original agreement, which makes kind of the whole process a lot easier. So you might be hearing when you talk to your technology administration, like, oh, we need to get an agreement with this. You know, I want to use Nearpod in my classroom, so we need to get an agreement with Nearpod. That could take just weeks, very quick, for them to come to an agreement because they can piggyback on an agreement that already exists. Or it might take months because your district has to come to a unique agreement with that EdTech vendor, and your district's lawyers have to review it, and the EdTech vendor lawyers have to review it, and things have to go back and forth, and it can be a whole process. So this whole thing can take weeks to months to reach these agreements. I think that it's really important to note that I've been saying every district has to have an agreement with every EdTech vendor. If you are using just a website, like you're having your kids go to the Chicago Tribune to read an article, and the Chicago Tribune isn't collecting any data from your kids, they're not signing up for anything, that's totally fine. Your district doesn't have to have a DPA. You don't have to get permission from your district to do this. Another great example, Starfall. Starfall has a bunch of activities that students use and do, but they don't need to sign in for anything. So if a student doesn't need to log into anything, that website does not have to be SOPPA compliant, and your district doesn't have to come to any agreement with them. However, if that service or website is storing any student information, then your district does have to come to an agreement, and you do have to have that agreement. Look, data breaches happen, unfortunately. And so there was a major data breach in Ohio. It led to years, I think it was 5 years of student and faculty information being published on the web. And I got this story from October 2020, but I kind of followed along with this. The district tried to offer credit monitoring and things for all of their staff, but they noticed once that information got published to the web, all of a sudden students and faculty members, their identities started to get stolen. And it really became a huge issue for a lot of people. So not only can data be stolen though from schools, but it can also be stolen from these third-party, these EdTech vendors, your Nearpods, Pear Decks, ed puzzles. So it's really important that not only your district is putting in good security practices, but also these third-party websites that we're using and we're having our students sign up for. It's really important that they're also doing their due diligence in protecting student data. So day-to-day impacts. What does all this mean? Well, ultimately what it means is all software that requires students to log in must now be approved by your district. Any past pieces of software, paid or free, needs to be reevaluated by your districts. And in terms of the free tools, your district technology leaders, they might not know what you're using. So you really need to talk to them about that. If an ed tech vendor won't agree to your district's contracts, you unfortunately can't use that software anymore, even if it's free. So again, I think it's really important for me to distinguish between what your district needs to have an agreement with and what they don't. If you're using software or a website or a service that your students are signing up for, they're logging into, that service needs to be approved by your district. Okay. If you're just telling your students to go, to the Chicago Tribune and read an article or visit a website, and they don't need to log in to that website, and that website isn't storing any student data, then you don't have to worry about getting this agreement and vetting it through your administration. But if they are signing up, you have to make sure that it's approved by your district. So teachers, and this kills me to say this, because I really feel like one of the best parts of being a teacher is being able to do what you feel is best in the classroom for your students, because you know your students better than anyone else, and you know what's going to help them. And so I'm really a big advocate for teachers and letting them have autonomy in the classroom. But unfortunately, teachers will no longer be able to just have students register on behalf of students for software or services without that tool first being vetted and approved by your district. You won't be able to conduct pilots of software without district approval, and you individually won't be able to purchase or access tools for your students to use on their own. There's a chance that unfortunately some of the current tools that you are using will not be available next school year, because either your district won't be able to come to an agreement with that particular software or that company, or it's just taking some time. So you really have to wait for that agreement to be reached before you use the software. So what do you need to do? Well, first, you need to really confirm that all of the tools, apps, websites that you're currently using are listed on your district approved list. And we're going to get into what that looks like during our next session. So I know a lot of different districts are hosting these files and like what's approved, what's not approved in a lot of different ways. And I'm going to talk about how a lot of different districts in Illinois are dealing with this. But you need to figure out how your district is managing all this and figure out if they have approved stuff. And if they haven't approved it, you need to start communicating with your administrators and curriculum leaders about, hey, I'm using this tool. It's really important to be using in my classroom. Can you get an agreement with them so that I can continue to use it in the fall? So I left 5 minutes for questions. I was hoping I was going to have a little bit longer for questions, but I'm going to really dive into the Slido here. So if you guys have been asking questions on the Slido here, I'm going to go ahead. Hopefully they pop up here for me for a second. Oh, sorry about this. Hold on. Present with Slido. Of course, it didn't load. All right. So is Slido SOPPA compliant? That is a great question. So Slido has reached agreements with some districts. I think that it's really important to note that your district has to reach an agreement with Slido. So just because there's other districts in Illinois that have reached that agreement, your specific district and your administrators need to reach out to them. Now, because Slido already has, they already have agreed to some things with other companies, it's pretty easy for your technology administrators to be able to piggyback on those agreements that already exist and get those in. But yeah, so Slido is SOPPA compliant for some districts, but it's going to be really important that it's compliant with your district and they have an agreement with your district. How will independent schools be required to comply? So this is a really interesting question. The law is slightly different for non-public schools. I was just listening to some lawyers try to explain this to me earlier today. Ultimately, the difference has to do with the way that the districts are presenting the information. So a public school really has to be very clear about the information that, or the agreements that they have with all third-party and ed tech vendors and the data that those are collecting. Private schools don't have those restrictions. However, private schools do still need to enter into contracts. And if you are at an independent school, you still do need to talk to your technology advisors, the people that are above you in administration, and see what they're doing to make sure that things are SOPPA compliant. I will just say this right off the bat. SOPPA is a very broad law. And every time I hear somebody very smart, much smarter than me, talk about it, they always talk about how ultimately there needs to be some case law established around this law in terms of how they're going to interpret things like what is a reasonable security practice and what does it mean by an ed tech vendor versus a non-ed tech vendor and stuff. But what I know is, as a teacher, you don't want to be the one that gets that lawsuit going, right? You don't want to be the one that like says, I bet I'm fine. And then all of a sudden there's a lawsuit because you made your students sign up for something. So I would always be asking your administrators and checking in with them to make sure that the applications that you're using in your classroom are okay to use. And I'm part of all these administrative groups that are dealing with SOPPA right now. And I can tell you the conversations that they're having is, as administrators, they need to talk to their district attorneys to make sure that everything is okay to use. So I would say push things up the ladder. Ultimately, legislators and the courts will have to make some of these decisions as to what is SOPPA compliant and what is not. But I certainly, as an educator, would not want to be the one that is starting these lawsuits. And I think the law is really there to protect student data. We all want to protect students. So ultimately, doing our best to comply with the law is going to be really important. Teachers will ask about having students log in with fake credentials not tied to their name. What about that? So as long as the website or service is not collecting any student data that can be traced back to that student. Now, student names is one thing, but email addresses, geolocation, photos, address, okay, if any of that can be traced back to a student, then you need to have a SOPPA agreement with that ed tech vendor. I think that using a bunch of fake information is not a great way around the law. I think you should be talking to your administrators and your district leaders, and ultimately they should be just getting these contracts done. Again, we have all the way until July 1st to get this done. So I think letting your district administrators know, hey, I really like using this platform in my classroom. Can you work on making sure that it's SOPPA compliant? I think that that's the better way to go in this. What if a teacher has an account with a vendor and the district does not? So as a district employee, you're responsible for making sure that the SOPPA is followed. Ultimately, your district will be held liable if you have your students sign up for a website. So if you have an account with a vendor, you need to tell your administrators and your technology leaders that, hey, I use this particular service. I pay for this personally. I'm fine continuing to pay for it personally if you are, but you need to come to an agreement with them. And I can tell you, most districts across Illinois are working feverishly to establish these DPAs and these contracts. So I don't think it'll be any surprise to them. And you know, covering yourself is probably the best course of action right now. What about like generic non-student accounts, example student 1, student 2? So this is a very good question. If you have students log into a service using like a generic username and password, and all students just log in using this generic username and password, and that service does not store any student data, then that is fine to continue to use without a SOPPA agreement. However, I am fearful as an educator in making that determination myself. So everything that I do with technology, I'm having conversations with the technology leaders in my building, and I'm always asking them, hey, I use this. Is this okay? I'm not storing any student data. And they're like, yeah, Greg, you're fine. That's good. That's all I want. So I would be starting these conversations in your district. Don't just assume that, oh, like I got this, I'm good. I think SOPPA, it's really imperative for you to be having these conversations because you need to make sure that you're following what your district and your district's attorneys feel is compliant and not compliant, so that they can back you up if there's any, lawsuits or anything that are taken against you. So does this apply to technology used only by educators, not directly student access? I don't know 100% what this means. So SOPPA applies to any website that you use for educational purposes. There is some gray area in the law where it says that non-edtech vendors don't necessarily have to comply with SOPPA. So we're talking about like your Facebooks, like your Instagrams, things like that. But I think the law really specifies that you have to have, your district now has to have somebody that's in charge of student data and in charge of all this data privacy stuff. So even if a particular vendor is not SOPPA compliant, and your district okays you continuing to use that vendor, I think that it's imperative that your district know that you are using that and you've gotten the okay from them. So everything that you're using, you should just really ask your administrators to make sure that it's okay for you to use that. And if they say, look, we don't have a SOPPA agreement with them, then unfortunately you may have to stop using it. Districts across Illinois are applying the SOPPA legislation very differently. I know some districts who are being very passive about it, and other districts who are taking it very seriously. But I think that that's a decision that your district administrators need to make, and you need to really follow their lead in that. What ages is for this? So this is K through 12. So SOPPA applies for not college, but everything K through 12 in the public and private sector. For the SW virtual session, it was recommended that therapists have a release due to limited confidentiality. Schools refused to permit this. Does SOPPA help with this? So for this particular thing, I know, so my district is going through something similar. I don't really want to give away any of the specifics of it, but I will say that this is something that the district administrators and attorneys need to come to some type of agreement with outside, either occupational therapists or outside people. There's a lot of instances where you have people that work for the district, like tutors and things like that. A lot of times your district administrators really need to come to some type of consensus about that. But ultimately, SOPPA does apply to everyone in the K-12 realm, even people that like occupational therapists, people that work outside but contract with the district. Talked about Slido. Any idea about how this will impact sports and other events, streaming platforms like YouTube? Yeah, so I can tell you Google, and Google is real. The Illinois lawyers are working with Google and Microsoft and Apple, trying to come to some agreements. Google owns YouTube, just so you know. So hopefully there will be an agreement in place between Google and districts, or that districts can piggyback onto, so that sports can continue to be broadcast on YouTube and streamed. I am hopeful. I would not say confident, but I'm very hopeful, and that some type of agreement will happen. But until that does happen, I would come up with maybe a plan B. So like I said, probably Google will come to an agreement and everything will be good. But I can tell you no agreement between Google and any districts in Illinois has been established yet. And Google and YouTube are kind of part of that. So Amber, are there any questions in the chat that I can answer?
It looks like the only one, Greg, is as a social worker and during virtual learning, it was recommended we receive a release due to the limit to confidentiality as it related to virtual sessions. The school refused to permit this, which has left the social workers concerned. Does SOPPA have an impact on this?
So not directly. It does not affect that directly. And again, I think that that's something that I know our district in particular has had to come up with specific workarounds for social workers and other contract workers in our district. We've also had to deal with some instances where specific ed tech vendors are refusing to sign a DPA with us, and how can we continue to use those in our district because they're really important. And as a district, we figured out some solutions with our district lawyers. But I think that that's really important for your district administrators and your district lawyers to figure out that solution and make sure that they all think that everything is vetted, because ultimately the district lawyers are going to be the ones that are representing the district in court if a parent group brings upon a lawsuit.
Thank you, Greg. Another one that just came through. So public K-12 districts and teachers need to become SOPPA compliant after July 1st, 2021, or risk potential lawsuits, much like copyright infringement, but even more serious, correct?
Very correct. So ultimately, it's going to be the Attorney General in Illinois that is going to be monitoring to make sure that states are districts are SOPPA compliant. And I think ultimately, from all the lawyers that I've talked to, what they said is the Illinois state's attorneys are going to be looking to make sure that districts are doing their best right off the bat. So they're trying to establish these relationships. They're trying to implement really good security practices. Like I said, case law ultimately is going to have to be established for a lot of these things because there is some gray in the law. Yeah, a district can't just sit back on this and be like, well, I think it'll all be fine. Or this is too hard, because this is kind of onerous. There's a lot for teachers and technology leaders. There's a lot for people to do. And I know a lot of people are already taxed. But I think just sitting on your hands and going, I don't have the time to deal with this, it'll be fine for a year. I think that is the wrong attitude to have. You really need to be making best efforts here. All right. So I know we went way over, but I'm definitely going to have 10 minutes for questions next time. Thank you all so much for joining. I got even more. So if you're like, whoa, this is kind of a lot, we'll get into more logistics. We'll get into it a little bit more and hopefully answer some of the questions that you might have next week on Wednesday at the same time. Thank you, everyone. Thank you, everybody, so much for joining.
Greg, thank you so much. And thank you, everyone. The PDH information was in the chat. I will put it in one more time just to make sure that everyone has it. And we look forward to seeing you all next week. Thank you.